Good afternoon, everybody, and welcome to our webinar on medical negligence and hip dysplasia in teenagers and young adults. For those of you that are familiar with Zoom webinars, your video is automatically off and so is your audio. If you want to talk to us, you can use the Q&A section at the bottom of the screen, and you can submit your questions that way. For those joining us via phone, you can submit your questions via email at info@steps-charity.org.uk, and also the webinar is recorded today and therefore would be available later on in case you cannot stay with us today throughout the session. And my name is Loredana Gwich-Wyatt, and I'm the CEO of Step Charity Worldwide, and I'm very pleased to have here with me today Will Jones from Fieldfisher. Welcome, Will.
Hi, Loredana. Thank you for having me.
Thanks for coming back to present.
Pleasure.
Thank you very much. And obviously, we covered last time hip dysplasia, medical negligence and hip dysplasia in children, and specifically wanted to cover the areas for teenagers and young adults, given the many queries we receive and we have received in the past few months on this topic. So we have a series of questions we're going to ask you, Will, later on, and I know that you're going to cover some of the key areas we discussed today also through your presentations. But for those of you that are listening today, if you have key questions, as I said before, please submit them by the Q&A section at the bottom of the screen, or you can email them at info@steps-charity.org.uk. And now, Will, over to you and the presentation. Thank you, Will.
Thank you so much. So yes, I'm Will Jones. I'm a solicitor at Fieldfisher. And just a bit about me and my sort of workload. So I have around 20 hip dysplasia cases at the moment ongoing. So these are cases involving a late diagnosis of hip dysplasia. It's about sort of half of my workload. I do other medical negligence claims too, but have a very much an interest in hip dysplasia cases. Working very closely with medical legal experts, particularly orthopedic experts, work closely with Steps and Loredana. And I've settled 8 hip dysplasia cases in the last year, which has been great for the families, and we've been able to get some damages for the child and to put those damages into a trust for them for when they're older. So those provisions are there for them as and when they need it. I did a previous webinar, and it was a bit sort of general, and I know Loredana and everyone at Steps is interested in those potential claims where perhaps the claimant is slightly older, so they may be a teenager or a young adult, and whether there's provision for those people to bring a claim. And I thought it might be useful to run through those potential cases and some of the issues that come up. But I guess, and Loredana, I don't know if it's what you hear as well, but I would imagine that if a teenager or maybe someone in their 20s is diagnosed with hip dysplasia, the reaction is, how on earth has that been undiagnosed for so long? Correct.
Yes, they would like to understand whether it was not diagnosed at the right time, so when they were babies.
Right. Yeah, and how on earth was it missed? And I just thought it might be useful to explain that actually it's not, you're not alone. There are lots of people who are diagnosed later on in life. And some of the reasons why, firstly, it is called developmental hip dysplasia. So although that's a bit of a misnomer and it does tend to be present at birth, that's not always the case. It can develop later in life, and that may well be the case. It may well be that if a teenager is diagnosed with hip dysplasia, they weren't born with it. It did come on later in life. Obviously, there are different degrees of hip dysplasia. So, if you imagine, I'm going to play the expert for a bit. If you imagine the sort of the hip joint and the top of the femur, I mean, hip dysplasia is where it's not sort of snug in the socket, but it could be completely dislocated from that, which is obviously where it's much more easy to pick up. But it can be also what they call subluxated, where it's sort of not snug, but obviously the symptoms in those cases would be much more subtle, much more difficult to pick up. It could be bilateral hip dysplasia. I've seen cases where, because both hips were dysplaced, then it's slightly more difficult to pick up, because you don't always have the sort of the limp that you get with the normal hip and the one displaced hip. It's not your fault if it isn't picked up. Often, people have been told by their GP there's nothing wrong. They've been told by, various, other experts, hospital doctors, pediatricians, orthopedic surgeons who have said there's nothing wrong. So it's not necessarily, it wasn't that you should have known something was wrong. And, if you've been told over and over again that your hip is fine by experts, you're going to take that advice and get on with your life. And finally, it's very easy to miss it at birth. It's not a condition that's picked up particularly easily. The tests are not hugely specific. I'm sure people will remember, if they're listening because of their child has been diagnosed with hip dysplasia. Well, there is a sort of a physical examination done, the newborn physical examination, and the hips are sort of manipulated. But it's very, very often missed, because that examination is really not particularly sensitive. Now, if I have a new inquiry and the potential claimant is a bit older, the first thing that sort of lights up in my head is there an issue with limitation? Now, limitation is it's part of the Limitation Act, which says that a claim for medical negligence should be brought within 3 years of the date of the alleged negligence. And it's designed to sort of stop proliferation of claims. Now, if the potential claimant is a child, it's different, because that 3 years does not begin to run until that child's 18th birthday, i.e. when they become an adult. So if it's a child, the limitation to bring a claim is the 21st birthday. So if it's a child, if it's a teenager, there's no danger of having missed the opportunity to bring a claim. When I say to bring the claim, I mean to formally issue the claim at court. But the other way that you can sometimes get round it is if the potential claimant is over 21 and the alleged negligence happened more than 3 years previously, you can use what they call date of knowledge. Now, what that tries to do is it tries to make it fair to people who didn't have knowledge of the negligence at the time, or even within the 3 years that the negligence took place, and it's only recently come to light. So maybe they've only just been diagnosed with hip dysplasia. Or maybe they've only just realized that, you know, it was negligent to miss that hip dysplasia, and potentially you can extend limitation that way. So with that in mind, if the claimant's under 21, it should be fine. There won't be a limitation issue, even if it was, you know, 18 years previously. That should be fine. What I would say though is try and do it as soon as possible. Don't ring the day before your 21st birthday, because that could be tricky. But even if the claimant is approaching 21, there are things we can do in order to extend the time. So we can agree an extension with the defendant. We can also do something called issuing protective proceedings, which effectively sort of stops the clock running. But it's very important to do it, you know, before limitation runs out, so you don't then have to try and argue for you don't have to try and argue with the court that limitations should be extended. Where these cases are slightly more difficult is if the claimant is over 21 and the negligence took place more than 3 years previously. Now, that's where we try and use something called data of knowledge if it's applicable. However, it's not always straightforward. And it's often something that we would have to try and sort out before we even look at properly investigating the claim. And we may try and see if we can decide it as a sort of a preliminary issue, or we can agree it with the defendant. But I don't want to get too deep into the law here, but what the courts will look at is how much knowledge did the person have at the time. The more knowledge they had at the time, the less likely it is that we would be able to argue that the knowledge has only recently come to light. So if at the time that person was aware that the injury was significant, they were aware that it was the fault of a person or certain people or a hospital or a GP or whoever it is, and they were aware of who the defendant was, then it may well be very difficult to argue that the knowledge has only just come to light. And obviously the less knowledge that they had at the time, the stronger the argument is that limitations should be extended. Now, every case has to sort of be on its merits. So, for example, I've got a case at the moment where the primary limitation has expired and the potential claimant is in her mid-20s. But it only came to light very recently that her hip dysplasia could and should have been picked up at birth, and that was as a result of her reading an article in a newspaper that talked about how hip dysplasia should be picked up, that it should be diagnosed and can be treated very easily if it's picked up in the first sort of few weeks and months of life. And she'd sort of gone on just thinking, well, it's one of those things, it's unfortunate, but, you know, it actually wouldn't have made much of a difference to the outcome, even if it had been picked up, because it's just hip dysplasia and I live with it. And there wasn't that knowledge that, you know, a Pavlik harness can be fitted very soon after birth, and a normal hip can normally develop after that. The one thing I would say, and because I don't want to sort of put people off, is that if you've only just been diagnosed with hip dysplasia and you're over 21, well, that shouldn't be a problem, because you couldn't have possibly had knowledge of it before then. So I think that's an important thing to point out. And I think it does happen. Loredana, you probably know more than I do about it, that people can be diagnosed sort of later in life, in early adulthood.
Yes, correct, absolutely. And then there's a question of, as you said at the beginning, whether it was hip dysplasia that was there basically at birth and could have been corrected with the public harness, or whether it was developmental hip dysplasia, so developed later in life. And I guess one of the key questions that we get asked most of the times, Will, is we have, for example, adults that say, well, I recall my mom talking about me being breech but obviously because the parents didn't have the necessary knowledge of hip dysplasia at the time, and they were not offered an ultrasound, they didn't even think about hip dysplasia. And then here they are when they're maybe teenagers, or when they're young adults, being diagnosed with hip dysplasia, and obviously coming to us and thinking, well, shouldn't have been then detected back then. Why only now? And obviously the reason why they're quite keen to understand a bit more is because some of them, unfortunately, then have to change completely what they're doing in terms of maybe their career path. We had people that are, were going to be professional dancers. So we have people that had a career in sport, and that now unfortunately is gone completely, and had to retrain. And so they're asking the question, but what are my rights here then? Should have been picked up.
Sure. If it should have been picked up, again, if they're over 21, then it would have to be, we'd have to look at seeing if we could argue this date of knowledge and extend limitation that way. But yes, if there were those red flag symptoms at birth, like breech position, latter stages of pregnancy, or something like that, then absolutely it should have resulted in an ultrasound, which would likely have picked it up. We've looked into that quite a bit, actually, with the cases that I've done, and the sort of types of employment which are not going to be possible for certain people, because the things that involve, dancing's a good example, but it's also things that involve a lot of physical activity. So armed forces could be out, joining the police may well be very difficult. And a lot of the evidence that we get from the orthopedic experts is that a sedentary job is going to be better for this person. Now, obviously, a lot of the claimants in the cases I work on are very young, so it's very difficult to actually say, well, we think they would have done this or that. But what that means in practice is that the claimant is put in at a disadvantage in the labour market. So you can recover. So you can't sort of work out to the penny what loss of earnings they're going to have, but you can say, well, if they're at a disadvantage in the labour market and they can't do these certain jobs, there's a sort of a lump sum that you can attempt to recover for them as a result of that sort of lack of choice in terms of careers. The other thing that where the courts can say is if you can sort of get over that hurdle of the date of knowledge, and you can say, well, I have only just realized that I potentially have a claim, then I would really sort of strongly recommend that you contact the solicitor ASAP, because the courts will look at what did you do when you did get knowledge, and it's their discretion. They can say, well, you know, yes, the date of knowledge was, you know, after limitation had expired, and it was in your 20s, or let's say, but even after that, you waited for 2 years before you did anything. So once you have that date of knowledge, it's a very good idea to speak to a solicitor straight away, because it's, you know, it is a discretion thing with the court, and the more you can sort of, you know, the more that you can kind of argue your case, the better. So if you say, well, yes, I just realized that, you know, it could have been picked up when I was younger, and I've just realized that it could have been treated with a Pavlik harness, and, you know, later that day I phoned a solicitor and here's the proof, and, you know, that's a much better argument for extending limitation. There's a few other difficulties that you can run into. I mean, they're not necessarily difficulties, but they're sort of issues that need to be considered. So if a case is older, you're obviously going to have to look at whether the medical records are still going to be available. Now, medical records should be kept until the child turns 25. That's what the guidelines say, but it's not always the case. We rely very, very heavily on medical records. So if you can't get hold of the relevant medical records, it does make bringing a claim much more difficult. So it's just something to sort of keep in mind. It probably wouldn't be an issue if you're, you know, if it's a teenager. Those records should still definitely be available. But as the potential claimant gets older, that risk sort of increases. And again, what was the standard of care expected at the time? So, you know, if you're going back sort of 10 years, well, you know, it's going to be pretty similar. The guidelines haven't changed that much. And actually, the guidelines in terms of picking up hip dysplasia haven't changed that much for a long, long time. And I think it's probably part of the reason why there are still so many cases which are missed, because actually back in, I think, the mid-80s, the rate of picking up hip dysplasia was no worse than it is now. So it actually hasn't sort of evolved that much. But obviously, if you're going back and back and back and back, you may well find that the standard was different. That maybe, you know, for example, if there was a slight concern about the hips during the newborn physical examination, you didn't have to perform an ultrasound straight away. But certainly, if we're talking about the last sort of 20 years, I don't think there's much of a difference in the standard of care. Minor point really, but if we get far enough and the claim is successful and we look at recovering past losses, you know, often parents have incurred expenses and they've had to they've incurred travel expenses, they've had to provide extra care for that child who was, you know, who needed more care because they weren't mobile, they were slightly vulnerable, it becomes more difficult to remember those things, and sort of, you know, proving that you bought certain things becomes more difficult. But that's absolutely not sort of a prohibitive thing to bring in claim. And in fact, none of those three are, but they're just, you know, they're just things that need to be sort of considered. So just as a sort of a bit of a summary, if the potential claimant's under 21, then there's not a problem in terms of limitation. So not a problem in terms of bringing a claim, but obviously the closer that person is to 21, the more sort of urgent it is to speak to a solicitor. If the claimant is over 21, then you know, I would, as a solicitor, go through it with them. Why has it taken this long to contact a solicitor? what are the reasons, what was the date when you had this knowledge. Important to act as quickly as you can. And it's true that it's more difficult to bring a claim where primary limitation has expired, but it's absolutely not impossible. And if there are good reasons for it, then it shouldn't matter. And Loredana, I don't know if you're happy for me to continue. So basically, all I was going to do is sort of repeat a bit about claims in general, just because limitation is one aspect. Limitation sort of allows you to bring a claim if you can get around any limitation issues you may have, but you still then have to prove the normal things that you have to prove in a claim for negligence. And I do sort of speak more about these in the previous webinar, but you've got to show a breach of duty and you've got to prove causation. Are you happy for me just to run through these once?
Yes, it would be. Yes, it would be good. We do have some questions that have come in, but I can ask you later on, unless you're happy to take them now.
Great. No, I'll run through this, and then we can look at any questions. It won't take long. So those opportunities to diagnose hip dysplasia, Loredana mentioned them, the breech position earlier. That's a real red flag. If the baby was in the breech position in the latter stages of pregnancy, there really should have been an ultrasound. It's very clear in the guidelines, and if there wasn't, then there are very good sort of prospects of a successful claim. Certainly, it would be considered breach of duty. Also, family history of hip dysplasia is very important. Probably immediate family, parents, siblings. Slightly weaker argument if it's if it's an aunt or an uncle, but could be significant, particularly if it's if there were other symptoms as well. Yes, and as I mentioned, those Barlow and Ortolani tests where the newborn physical examination is done, and they're very low. They have low sensitivity, so competent practitioners can do those tests very well and still miss hip dysplasia. But it's important that they do them. And then there's a 6 to 8 week exam with the GP. That's often one of the first opportunities to pick it up if it's been missed in the newborn period. Often parents will take the child to the GP, take the baby to the GP, having noticed certain symptoms. I've seen, there's an unusual sort of buttock creases, they're not symmetrical, looks like a leg length discrepancy. So the GP should do a full physical examination at that 6 to 8 week check, and should be with the nappy removed as well. And then other opportunities as the baby gets a bit older. So there may well be, ad hoc visits to the GP, or there's the check at about a year. There'll be health visitors seeing the baby. And then, as I mentioned, that's what you've got to show to bring a successful claim. You've got to show there was a breach of duty. And that's how we look at it. That's how we test whether there was a breach of duty. So no reasonably competent body of practitioners practicing in that field at that time would have acted in the same way. And we rely on experts to tell us whether there's a breach of duty or not. And so if you can show there's breach of duty, you also have to show causation. Is the current condition of the potential claimant a result of that breach of duty? Doesn't have to be completely. They may well, even if there wasn't a breach of duty, they may well have had problems with their hips. That's fine, but has it at least contributed to the severity of the injury? And that's all I had to say. Very happy to take any questions.
Yes, thank you. Thanks, Will. So we have received some questions, and I welcome others to submit them through the Q&A sections at the bottom of the screen. So one of the questions that was asked is related to the details of the medical records. You talked about medical records, and what if the person does not have or doesn't remember all the appointments that they had? So who don't really have all the medical records? Who's responsible of getting hold of them? Isn't there a procedure to maybe reach the various doctors or health professionals?
Yes, so that would be me who would access the medical records. So what I would do is I would get I would do a form of authority which the parent would sign, and I then request the records, and if it's hospital, I request them from the trust. If they're GP records, I request them from the current GP practice, who should have all of the current and historical GP records. So that's certainly not something that the parents need to do. They will often have a copy of the Red Book, which can be quite useful in these cases because it does record some of the physical examinations, and that's often something that the parents have and keep. But in terms of getting records from the hospital or the GP, that's absolutely for me to do, not for them. But when I said it can be tricky, it's because there are instances where records go missing, or if records are a certain, if they're old enough, they may well have been destroyed. So, and that can be an issue in bringing a claim. But yeah, no, we take as much burden off the parents as we can. So.
And the other question that we have is related to when you're informed of the condition, because we have several adults that it might take 3-4 years to be diagnosed with hip dysplasia, because they're passed from one consultant to another, or they go to the GP, then a physiotherapist, then back to the GP, because obviously the pain is still there. So when exactly is it at the point of a diagnosis that? Yes,
it almost certainly is when they're told that they're diagnosed. That's when the 3 years should start to run. I mean, obviously, if it's a child, if this is happening to a teenager and they're going, back and forth to consultants, well, actually, that shouldn't matter too much because, limitation is not a problem anyway. If the person is over 21, then it's slightly trickier. But until you've got a diagnosis, how do you know that there's something really wrong? I mean, and so I think it would be incredibly unfair, and I don't think the courts would say, well, actually, you went to see this, I don't know, this orthopedic expert 4 years ago, and they said there might be something wrong, but they weren't sure, and they wanted to do some more tests, and they wanted to refer you to somewhere else. Well, then, I think it would be grossly unfair for the 3 years to start running then. It's once you've been told, this is your diagnosis, this is what's wrong, here's the imaging confirming it. So I certainly don't want to kind of scare anyone into thinking, well, they haven't got a case because of their age or whatever. That there are issues you've got to consider, but if there are good reasons from deviating from that quite strict three-year time limit, then courts are, I would say, pretty reasonable. It's just, you can't sit there for 20 years having known that you had a diagnosis and then suddenly say, I'm going to look into that and see if I've got a claim. That's the thing. There has to be some degree of urgency in sort of contacting the solicitor and saying, can you look into this for me? And it's not that hard, you just pick up the phone and say. So yes, it should, if there are reasonable grounds for extending limitation, then I think, they should be extended.
You should be able to extend it. And there's a question that has come in related to, I guess, and we talked about this at previous webinars too, how many times do you have to go to the GP and be told you have nothing or not to be referred for it to be really perceived to be medical negligence? Yeah. And I guess that's quite a key question, especially for adults, because with adults you tend to go back and forth many times.
Yes.
When you have actually a diagnosis. So I guess first question is how many times, I guess, before one could say, well, it should have been spotted like a year ago and it's clear case of medical negligence. And then the second actually that has come in is, but what if I was diagnosed later on in life with hip dysplasia and it took doctors 5 years?
Yeah.
There was no key signs when I was a baby. Isn't that also medical negligence?
Yeah.
Sorry.
Okay. So first question. Yeah. I've always sort of been aware that there's a bit of it's an unwritten rule, but I think there's a bit of a 3 strikes rule with general practice, that if someone goes to see the GP 3 times with the same symptoms and no diagnosis is made, well then it may be time to refer. Obviously it depends on what those symptoms are and the severity of it, but 3 might be sort of a good rule of thumb. But there may be cases where more than 3, there's no negligence even if you've been 3 times. I suspect if you're talking, if you're complaining about hip dysplasia symptoms, then 3 might be a good sort of rule. But the one thing I would say is it really depends on the individual facts, because I've got cases where there was only one visit to the GP and there was a failure to refer, and that can be negligent because it depends on what happened at that visit to the GP. It depends on what symptoms were described. It depends on whether the GP checked properly, because it may be that the GP sort of completely dismissed it, and had they done a physical examination, which they should have done, and probably sort of removed the nappy as well, that they would have found, or they would have at least suspected hip dysplasia and they would have made a referral. So I had a case where I think there were 6 visits to the GP. And I think in that one, it was around the 3rd visit that ended up being admitted negligence. I think it probably can be as few as 1 if the symptoms were described and a physical examination didn't take place when it should have done. I think it probably could be more than 3, but I suspect if there's 3, that would probably be considered negligent by a GP expert. And sorry, Loredana, remind me of the second one.
Now the second one is specific to a late diagnosis in adulthood.
Yeah.
Where it takes 5 years to diagnose hip dysplasia, and in those 5 years, a person could, can have, there could be serious consequences with mental health, obviously mobility, losing their job. And the question is, even if maybe there were no signs of key signs of hip dysplasia when they were a baby, that a case of medical negligence because it took doctors 5 years to diagnose hip dysplasia eventually in adulthood. We're talking about.
Yeah, quite possibly. There's a case there. You'd obviously have to go back through the history, because what I would always try and do is you want to try and establish the earliest possible breach of duty, because what that means for the case is that the earlier the breach of duty, the better the outcome would have been, but for any negligence. Now, if you're saying actually the breach of duty was when the claimant was, I don't know, 10 years old, and then there were 2 years of being passed around, and they were eventually diagnosed at 12, let's say, well, that's going to be a very difficult claim to bring, because actually what you're looking at there is what's the difference in the outcome from being diagnosed at 10 to being diagnosed at 12, and then you put a monetary value on that, and that's what the claim is. Now, I don't think there's going to be much of a difference in that outcome. So if you're talking about adulthood, well, yes, I think there could very well be a breach of duty there in failing to diagnose hip dysplasia for 5 years. What difference is there to the outcome? Now, it might be that the hip actually, they may perform surgery and actually go, the prognosis isn't that different to what it would have been had it been diagnosed 5 years earlier. But obviously, if there are other losses, then yeah, I think that's certainly a potential claim. I'd obviously want to know why it took so long to diagnose. But yeah, age shouldn't be prohibitive. So yes, I'd certainly be interested to speak to them and see what we could do.
That's right. Thanks, Will. I think we have answered all questions. And for those of you that still have questions and would like to submit them later, please do send them either to us at info@steps-charity.org.uk or to Will directly. And your email is there, Will, for them to note down. And I'd like to thank you for your time today, Will. Thank you very much.
It's a pleasure. Thank you so much for having me.
Thanks. Thanks for being here with us and supporting our families and adults. And obviously, as I said before, if there are further questions, please do contact us. Otherwise, I wish you all a good end of the evening. Bye-bye, everybody.